Hello, everyone, and welcome. My name is Melanie O'Brien, and you have joined the National NAGPRA Program's monthly webinar. This webinar is being recorded. If you do not wish to have your name recorded as attending this webinar, you may disconnect at this time. Today's webinar will focus on the role of notices under NAGPRA, and in particular, notices under the revised regulations. I have a PowerPoint slide which I am going to share to assist me with today's webinar. The slides that are contained in this presentation can be found in the larger presentation that is posted to our events page, and I will put a link to that in the chat. You can go to the National NAGPRA Program's events page to find recordings of past webinars, as well as a PowerPoint presentation with these slides included. In addition to the PowerPoint, I will also be referencing other pages from the National NAGPRA Program website, including our templates page and our database page. And I've included those in the chat as well. Okay, so to get started, today's webinar will focus on the role of notices under NAGPRA. This is a table of contents from the Act itself. Again, NAGPRA, the law that was passed in 1990. And in particular, we're going to focus on sections 3003, 3004, and 3005 today. I will note that there are notices that are required under 3002, which is the process for protection on federal or tribal lands, but we won't be addressing those notices in today's webinar. Instead, our focus is going to be on repatriation of human remains, associated funerary objects, and other cultural items. The slides that I've prepared are similar to the last two webinar sessions, where there's a focus on what the Act itself contains, and then what the regulations require. So again, the Act includes notices in two places, with human remains and associated funerary objects in particular. Notification is included as a part of the inventory process, and then options after a notice is published are contained in the section on repatriation. So the law requires that after an inventory is complete, 6 months after that, a notice must be prepared to notify Indian tribes and Native Hawaiian organizations about human remains and associated funerary objects, and indicate those that are clearly identifiable, as well as those that are reasonably determined to be culturally affiliated. Again, this is the language from the Act itself, and it's concluded by a statement that a copy of each notice is published in the Federal Register by the Secretary of the Interior. This is the extent of the information in the Act about what a notice is, what it must contain, and who has to publish it. The opportunity that comes after a notice is published for human remains and associated funerary objects is for Indian tribes and Native Hawaiian organizations to make requests for repatriation. Again, those requests for repatriation follow the notice for human remains and associated funerary objects. Again, this is the language from the law. about how those requests can be made. So shifting to the regulations, this is the table of contents from the regulations. And again, we're focused here on the repatriation subpart. The requirements in the regulation, as many of you know, have laid out a step-by-step process for the repatriation of human remains and associated funerary objects. And you'll see in this list that the notice, submission of a notice, comes in step 5. Again, just as it was explained in the Act, after the completion of an inventory, a notice must be submitted and then published in the Federal Register. In step 5, submission of a notice, there are things that are required, that's under the check mark. Things that are not required, that's under the X. And then areas of discretion in what the notice contains. So information and determinations from the inventory are required in a notice. The number of individuals as well as the number of associated funerary objects is required. Contact information for the museum or federal agency that is publishing the notice is required. And then there needs to be a calculated date on which repatriation can occur after the notice is published. In the middle section, these are things that are not required in a notice. We often see them in a notice, and it's okay to include them. But I want to stress with this slide that these are not requirements for a notice. There's no requirement for site numbers or accession numbers. There's no requirement for specific detailed information about the human remains included in the notice. Some level of detail is needed for the associated funerary objects to identify the types of objects included, but not exhaustive detailed information. And then in the last column, it is up to a museum or federal agency how it organizes that notice and the level of detail that is included. How long should it take to submit a notice? It can take no longer than 6 months after completing an inventory. Again, that's directly from the Act itself, that a notice must be submitted 6 months after completion of an inventory. In theory, completing a notice could happen much faster, especially we hope that the templates that we've provided can assist in completing a notice more quickly. Again, with regard to the notice templates, this is again a screenshot from our website. I will go ahead and repost that link for anyone who might have joined late to the templates page of our website. Under repatriation of human remains, we have a template for a notice of inventory completion, for lineal descendants, or a notice for cultural affiliation. And we are right now working to finalize the notice for where there is no lineal descendant or no cultural affiliation. We expect to have that hopefully next week or the week after, and it will be available again on our template page. This is the template, what the template looks like. It's a Word document that you can download and fill in. We have worked very hard to provide you with clear and concise directions on the first page of the notice template. It's important to note that use of the notice template is not required, but it is highly encouraged because this is how you can ensure that your notice will be accepted by the National NAGPRA program for publication in the Federal Register. Much of the detail in the notice template is actually related to the Federal Register requirements. So it is very important that you not make changes, especially to the headings, the spacing, or even the font. All of those are elements that are required for publication in the Federal Register. So the notice, while it encapsulates the information that is needed, it really is more about the format and style that is required for the Federal Register. Those requirements are very particular, and part of our job is to ensure that any document that we submit to the Federal Register meets those requirements and standards. So again, the first page includes instructions. It gives some context for when this template would be used. It outlines the 7 pieces of information in this case that you need to fill into the notice. And again, stresses not to make changes to the headings or sections, and especially to the date that is in brackets, and you can see on the first page. That is instructions to the Federal Register for them to calculate the date when the document is published. Again, we ask that you remove the instructions before you submit your notice. You need to be sure that you verify any of the information in the notice, especially any numbers that are included or addition. This is where we see common problems with notices that include inaccurate addition. Just simple math can be wrong in notices. And so it is, again, the obligation of a museum or a federal agency to ensure that that is all accurate. And then we've included on the instruction page where to send the notice. It gets sent to NAGPRA_info@nps.gov. And then the process for publication. You can see on the right side of the screen, the template itself with the highlighted sections in yellow, where you, a museum or federal agency, would insert the necessary information. This is pages 2 and 3 of that notice template. Again, very concise information that is required. Again, going back to that slide about what is required, the template includes all the information that is required, but none of the information that is not required. You can choose to add extra information if you wish, although we would discourage you from doing so, in part because it will cost more to publish a notice that's longer, but also because it is not necessary. The notice templates have been around for a long time. They've been revised over the years, and this reflects the latest iteration of the notice template, similar in a lot of ways to previous templates, with some minor changes related to the new regulations and the new regulatory requirements. The focus of a notice is really on this determination section, where it announces what decisions the museum or federal agency has made related to the human remains and associated funerary objects. And those decisions are how many individual human remains are included, how many associated funerary objects are included, and who is culturally affiliated to those human remains and associated funerary objects. A lot of times, I think that people have a different view of what a notice is, and maybe put the emphasis more on this abstract section here, the first paragraph on the left side, as some kind of chronicle or record. But that is not the intent of a notice, and that's not what the focus of a notice should be. The focus is on these decisions that are being made by the museum or federal agency for purposes of repatriation. And that brings us then to the last page of the notice template. What comes after the notice, again, thinking back to the process in the law and the regulations, after a notice is published, it's an opportunity for a request for repatriation to be received from Indian tribes or Native Hawaiian organizations or lineal descendants. And that's the concluding piece of the notice template. Sorry, excuse me. This table is one that you've probably seen before and that we've shared in other presentations. It's a part of our Steps to Repatriation document, which you can, again, find on our website. And it outlines a timeline for repatriation. from the first day that a new collection is received to go through the process for repatriation. And you can see that in terms of the notice timeline, there is at minimum, the very fastest way we could publish a notice is 3 days after it is received. And that is if we can take the notice and get it to the Federal Register the same day. It's a minimum of 3 days to publish a notice in the Federal Register. It takes more time than that generally, but the maximum amount of time for publication of a notice in the Federal Register is about 26 days. We've been able to move quickly in some cases with publication, but generally we have quite a load of notices that we're working on, and we go through the notices in the order that they are received, and all of them are published in about 26 days. Some a little sooner and some a little longer. There is a regulatory requirement for publication of a notice, I should say for accepting a notice for publication, and that has to be done within 21 days of receipt. So again, going back to the notice template and the instruction page, you'll see that according to the new regulations, no later than 21 days after receiving a notice, the manager of the National NAGPRA program, me, will either approve the notice for publication or return it to the federal agency or museum for changes. So you can be assured that 21 days after you submit a notice, you'll get a response on whether it's been accepted or not. Or I should say, you'll get a response if it's not been accepted. Otherwise, we'll move through and continue to the publication process. And then, of course, it is after a publication of a notice for human remains and associated funerary objects that a museum or federal agency can then receive requests for repatriation. So again, in the process for human remains and associated funerary objects, it's important to remember that the request for repatriation comes after the notice is published. So where can you find notices that have been published? We have on our website all of the published notices. And I will share again the link to this page, the database page, where you can find the notice database and look at any notices that have been published in the Federal Register by the type of notice. And there's an active link that will take you then to the Federal Register notice so you can read that. Okay, I'm going to pause here for a second. I'm actually going to go back to the template for a notice of inventory completion. I want to emphasize again the role of the notice, and especially the notice of inventory completion. As the title suggests, this notice is to notify Indian tribes and Native Hawaiian organizations that an inventory has been completed. It is a notice of inventory completion. And it is this document, this publication of a notice of inventory completion, that provides the opportunity for Indian tribes and Native Hawaiian organizations to then make a request for repatriation. This is the basic process that is set up by the law itself, and the regulations, again, provide additional clarity and instruction, and then the template builds on top of that, even with more direct guidance and advice on how to complete these requirements. So it's important to keep that in mind, what the purpose of this notice is, and that it is intended to be a short, brief document that provides the required information and in the format that is required by the Federal Register. You will see at the end of the notice There is a citation to the authority, which is NAGPRA itself, as well as the regulations. And then you will see that it is the manager of the National NAGPRA program that signs the document for publication in the Federal Register. So again, it will be dated and signed by the manager of the National NAGPRA program before publication in the Federal Register. Okay, I'm going to move on to the other section of the repatriation provisions, and that is for other cultural items. I'll use the phrase other cultural items as a shortcut, but by that I mean unassociated funerary objects, sacred objects, and objects of cultural patrimony. Again, in looking at the law itself, these are objects, cultural items that would be included generally in a summary. And the repatriation of those objects is covered in the Act through requests for repatriation. You will note that in the Act, there is no requirement for a notice for other kinds of cultural items. And while there is no requirement in the Act for the notice, this has been a part of the regulatory requirements since 1993, finalized in 1995, as a way of ensuring due process, transparency of what has been requested for repatriation and what is being repatriated under the summary provisions. So in the Act, the provisions are that Indian tribes and Native Hawaiian organizations may request repatriation of these items. There is a requirement in the Act that that request be supported by a finding regarding right of possession. In addition, the Act provides some more specifics on how objects are requested under the summary provisions. Again, for repatriation of other cultural items, there is a requirement to show cultural affiliation, as well as to show that the object meets the definition. So again, this is the limit to what the Act itself provides in terms of the process for repatriation of other cultural items. The regulations provide additional guidance for this. And again, different set of steps here for repatriation of other cultural items. And you will see that unlike the inventory process, the notice in this part of repatriation comes after a request. There's a fundamental and significant difference in the process, the steps to repatriation for human remains versus other cultural items. And the regulatory steps reflect that difference. Again, a very similar list here of what is required, what is not required, and then where there is some discretion for the museum or federal agency. There's a different timeline in a notice under the repatriation of other cultural items. And that difference is that, again, because a request for repatriation precedes the notice, then the notice is required 30 days after agreeing to repatriate based on that request. So there is a much shorter timeline here, again, because of the requirement for a request for repatriation. Again, if you look at our template webpage, I will add the link again, just in case anybody came in late, to our template webpage. You will see that we have templates for notices of intended repatriation for lineal descendants and cultural affiliation. And this is, again, a similar look, but different different information included in a notice of intended repatriation. Again, the first page is the instruction page and clarifies that this notice is only used for unassociated funerary objects, sacred objects, and objects of cultural patrimony. And it is only used after a request for repatriation has been received. And the museum or federal agency has responded to that request for repatriation. So this template is, similar in some respects, although there are only 6 pieces of information that have to be included in this notice. And there are other options within this notice for what type of object is being included. So you will see starting at the bottom of page 1 here, the first requirement is to include a total number of cultural items. And then on the next page is where you pick which of the descriptors is appropriate for the objects that you are including in this notice. If they're unassociated funerary objects, sacred objects, objects of cultural patrimony, or objects that are both sacred objects and objects of cultural patrimony. There is a requirement to, again, describe generally the types of objects included, as well as to include some information, if available, about the collection itself. The determination section, again, for notice of intended repatriation is the critical part. It identifies the number of objects as well as the tribes that have made a request for repatriation. And it is important to ensure, again, that you are doing the math correctly, that the total number of cultural items in the paragraph above matches the numbers that you list here in the determination section. The determination section should include only those bullet points that are appropriate. So if it is an unassociated funerary object, you would only use that bullet point and delete and remove the others. An important point that I did not mention, but is similar to the notice of inventory completion, is identifying the tribes that are culturally affiliated. It is important that the notice include the names of the Indian tribes, first in alphabetical order, and second, the names that are used in the Secretary's list of federally recognized Indian tribes. That list is published in the Federal Register annually by the Bureau of Indian Affairs, and the names that are listed in the notice should match the names that are in that list exactly. And then again, you'll see the last part of the notice is about, in this case, additional requests for repatriation. Because again, a notice of intended repatriation comes after an initial request, but does provide an opportunity for others to come forward and make requests for repatriation. We've developed a similar timeline for repatriation of other cultural items. And again, you will see that we've estimated the shortest timeline for publication of a notice at 3 days and a longer timeline, maximum of about 26 days for publication in the Federal Register after the notice has been submitted. Again, our webpage includes information of, publication of notices of intent to repatriate. You can find published notices here on our database page. I will go ahead and share that link again for anyone who came later. And you can look at the direct links to the published notices. In most cases, we're still working on populating the links in our database, but most of them certainly are here, and you can directly link to the Federal Register. I do want to take this opportunity to point out these two additional radial dials that are incorrectly named, and we are still working on developing this portion of our database for notices of intended disposition, which are related to the protection of human remains and cultural items on federal or tribal lands. Those notices are going to be published, have been published in the Federal Register, and soon our database website will reflect those notices. And there's an additional notice type provided for in the new regulations, which is called a notice of transfer or reinterment. And those also will be published in the Federal Register, and we will eventually have them here on this web page. So these are kind of placeholder radio dials for now, but you can expect them to be updated soon. That is everything I have for a presentation today. I'm going to go ahead and stop sharing. I'm managing today's session a little bit more independently. So I'm going to go ahead and open up the Q&A option. I do not have the chat enabled for this, but if you do have a question that you'd like me to answer, you may post it in the Q&A, and I will try to address it. We have been inundated by questions during these sessions, and I wanted to try to manage it a little bit more today. So could I restate which notices will be available on the web page that I was just showing? Yes, all notices that are published in the Federal Register will eventually be available on our website. So right now that includes notices of inventory completion and notices of intended repatriation. Eventually, we will also include notices of intended disposition, which are under the other piece of NAGPRA for federal lands, and notices of transfer or reinterment, which is a new kind of notice that has been included in these regulations. The next question is, do institutions need to submit inventories to National NAGPRA, or are inventories only meant for consultation with tribes? Thank you for the question. Again, inventories relate to human remains and associated funerary objects, and inventories must be submitted to the National NAGPRA program before the notice is submitted. So yes, inventories must be submitted to the National NAGPRA program, but they must be submitted after consultation. So consultation must occur before an inventory is complete and before it is submitted to the National NAGPRA program. For the new regulations on display, I think that this is in reference to the requirement in the regulations for consent prior to exhibition of Native American human remains or cultural items. Federal notice is not required. Is that correct? That is correct. There's no notice requirement related to acquiring consent for exhibition. Will there be a template to ask museums to comply with the updates about consultation on items on display? I think this is a question from a tribal perspective. We do not currently have templates provided for tribes. We do hope to provide some templates for requests for repatriation. But at this point, we don't have such a template. Okay, I have to, I'm sorry, but I have to try to manage these questions or they will get out of hand. So I'm going to go ahead and click these are done. Please bear with me. Okay. In the older regulations, there was a requirement for a notice in a local paper for a plan of action. Am I correct that a notice for a plan of action there's no notice for a plan of action in the new regulations? So this pertains to the other part of NAGPRA, the protection on federal or tribal lands. So not repatriation, but the protection sections under subpart B. A plan of action is required as it was previously. Previously, a notice of intended disposition was published in a newspaper. Under the original regulations, the requirement for a notice of intended disposition was publication in a local newspaper. That has changed with these revised regulations, and notices of intended disposition, again, only for protection on federal lands, is published in the Federal Register. That's the new notices that you will be able to see soon on our website. This is a helpful question. Someone has asked if a notice of inventory completion must be submitted before a notice of intent to repatriate or a notice of intended repatriation. The answer is they're different things. A notice of inventory completion is for human remains and associated funerary objects. A notice of intended repatriation is for other cultural items, unassociated funerary objects, sacred objects, and objects of cultural patrimony. There's no overlap between those two notices. They are completely separate things because they involve separate objects. Now, a lot of times we will see a museum or federal agency that has consulted on a collection that contains both human remains as well as other kinds of cultural items, and they will publish both a notice of inventory completion and a notice of intended repatriation at the same time for related collections. That's possible. It happens quite often. But they are two separate notices that cover very separate things. It's a common confusion. So I'm happy to answer the question and to emphasize. A question about requests for repatriation and whether they have to be written or they can be verbal. There must be a written record of a request for repatriation. If a request for repatriation is made orally during consultation, then there needs to be some way that that is recorded, whether that's in the record of consultation and the tribes making the verbal request agree to have it recorded and being written in that way, that's fine. But there is a requirement for a request for repatriation to be in writing in some form. And this is so that a date for that request can be established, because the request for repatriation is a key date that other timelines are related to. A question about the database and noticing that notices published before 1993 don't link to the actual notice. Actually, it's notices before 1994, so including 1993, and that is the limitations of the Federal Register online system only shows notices since 1994. The notices are available. They're available through the government printing office. Unfortunately, the web links to them go to the entire Federal Register publication, which is hundreds of pages long. We do have those links, and we are working on figuring out how to get our database to reflect them. But they are not as user-friendly as the links that are provided from the Federal Register after 1994. Again, it's a small number. It's about 20 notices that we are working on getting reflected on our website, but right now they are not available. Okay. All right, we have a lot of questions here that are actually not related to notices. So I'm just going to do a quick scan and see if I can identify some that are related. Here's a good one. Can you submit a notice of inventory completion that does not include human remains, but only associated funerary objects? Yes is the answer. We have published many of those. We have examples of those that you can find on our database. Again, you can see on the online database where the number of human remains and the number of associated funerary objects. If you sort that table, you'll be able to see those that have been published that have 0 human remains, but have associated funerary objects. There are many circumstances in which that might occur, and it is perfectly acceptable. Okay. Let me jump back up to the beginning here. And I'll go ahead and try to answer some of these questions that have been asked. You can upvote a question. So if there's a question that you also have, you can upvote that or like it, and that will raise it to the top of my queue to answer. Okay, if we sent out summaries in the 1990s, do we have to send out another document to tribes regarding any aspects of the duty of care, especially related to hazardous materials? If you sent out a summary in the 1990s for other cultural items and it generally describes your collection, then there's no requirement to update a summary or to resend a summary. The only requirement would be if you have additional collections that were not included in that original summary. If since sending a summary, you've learned about the use of hazardous materials, then you may want to reach out and report that to tribes ahead of consultation, but you will certainly want to include that in your consultation. You are obligated to disclose any information that you have, you being a museum or federal agency, about potentially hazardous substances that were used to treat the objects. That would certainly be a part of the conversation during consultation. Should notices be done as site by site, or can you have multiple sites in one notice? That's a great question. Not only can you have multiple sites in one notice, we would encourage you to have multiple sites in one notice. The organization of a notice is up to you as the museum or federal agency, and we would say it should be something that's discussed in consultation. So how you organize your notice, how you organize your collections is a museum or federal agency responsibility. We don't have an opinion on how that organization should be, although we will say that it's simpler for everyone if you make logical decisions about that organization. Now, there might be reasons why you want to separate collections in certain ways, maybe by site, maybe by collection or accession number, other reasons that you might want to organize a notice that will make sense to you in the repatriation process. But the emphasis should always be in any question you're asking and anywhere there's discretion in the NAGPRA process, what is going to benefit repatriation? What is going to help expedite repatriation? So how you organize a notice, whether you do it site by site or you combine sites in a notice, or if you don't refer to sites at all, because that is not required, that may be, there may be ways that you organize your notice that will be more expeditious in terms of getting to repatriation. I will say that from a purely mathematical point of view, the fewer paragraphs you have describing your human remains and associated funerary objects, the less chance there is of making math errors. So we definitely prefer shorter notices with more combined general descriptions because it reduces the risk of making a mistake. Should a federal agency re-inventory human remains and associated funerary objects if, excuse me, substantial time has elapsed since the last inventory? We have a collection nearing 40 years of age that has not been affiliated or requested for repatriation. So if those human remains and associated funerary objects have not been published in a notice of inventory completion, then yes, you have an obligation to update your inventory, reevaluate cultural affiliation, and publish a notice of inventory completion. The revised regulations require museums update inventory, museums or federal agencies, update an inventory for any human remains and associated funerary objects not published in a notice within 5 years. So by January of 2029. So there is an obligation to update that inventory under the revised regulations. And I will say that updating an inventory means initiating consultation, completing consultation before reevaluating cultural affiliation. Is there a way to see previous inventory submissions for our institution and the date of that submission? Yes, our database page provides inventories for human remains and associated funerary objects that have not been published in a notice. Again, if you go to our database page and click on inventories, you will see those human remains and associated funerary objects that have not been published in notices. If you need additional information, you can contact us directly, and we will provide you with information that we have about your more detailed information about your inventory. For other culturally affiliated objects, are there templates for summaries on the NPS website? We have developed that template. We haven't posted it yet. We do have examples of what a summary might look like that are available in our policy document. Let me paste the policy page. We do have a policy document for compiling a summary. And I would point you to that in lieu of the template, although we hope to have that summary template up soon. A summary template is not much of a document, I have to say, and it's just a letter. That is the extent of a summary, and there are lots of ways you might prepare a summary. The template is pretty bare bones, but we will be making that available soon. Is there a template or other information for lineage requirements to repatriate? I think this is in reference to a lineal descendant request for repatriation. We don't currently have a template for making a request as a lineal descendant, but again, as I mentioned before, we do intend to provide some templates for tribes as well as lineal descendants to make requests for repatriation. So please check back to our template page for that. Let's see, let me resort and see if, okay. Where on the website can we find a PDF cheat sheet for timelines, like what I shared during the presentation? Absolutely. That's the Steps to Repatriation document, has both of those timelines. Again, it's only for the repatriation provisions of the law. I was actually asked this week if we were going to develop something similar for federal agencies and federal lands, and we do intend to do that. I'll go ahead and post the direct link in the chat to the Steps for Repatriation document, and you'll find there those timelines. It's actually, I'm not sure that's exactly what you're looking for. That's the, hypothetical timelines are included in that document. But if you look at the Steps to Repatriation, we've included where there are timelines associated with each step. Give me a minute and I will find you one other place that you can look for sort of a comprehensive timeline, and that is in the final rule itself. We provided a table in the final rule that includes all of the timelines, and again, for repatriation, only for repatriation, but this might be the kind of document that you're thinking of, and that might be more helpful. So I'm going to put a link in the chat directly to the paragraph in the final rule. One of the things that's wonderful about the Federal Register in the modern day is that I can give you a link to the direct paragraph that is related to your question. And so that's what I've posted in the chat. Okay. All right. Someone asked about a drawing that was acquired and whether or not they need permission from the tribes to display the work in public. This is this is an interesting question and one that I can't give you a direct answer to. In the acquisition of a piece of art, drawing, painting, whatever it is, you need to ensure that you have clear records of the acquisition of that object. Whether or not that piece of art is considered, could be considered an object of cultural patrimony or a sacred object, really has a lot to do with what you know about the object itself. The answer to any question about whether you need consent to be able to exhibit an item is to evaluate what you know about an object and whether or not it is likely to fit the categories under NAGPRA. So I can't answer your question directly, although if this is a piece of contemporary art that's been acquired from a contemporary artist, obviously information from the artist will help you to answer that question. So I hope that is an answer, even if it's not a direct one. Is there a way to see summaries or to obtain copies of them? Yes, we have paper copies of inventories that were submitted to our office in 1993. We do not, because of the nature of a summary, we don't provide the same kind of detailed information on our website as we do for human remains. But you can reach out to our office if you want additional information about your summary. Although, again, we would encourage you to be sure you're checking your own files and ensure you don't have a copy of that somewhere, the document that was submitted. Okay, I'm just gonna take a little breath here. I appreciate all of the questions, and I appreciate your understanding and your patience as I try to work through as many of them as I can. Okay, let me resort. Again, you can upvote questions. How does a museum or federal agency know whether or not something in their inventory is culturally protected item without understanding the actual culture of the tribe or Hawaiian organization? Should they consult with different tribes where they can create criteria of what to look for so nothing is missed when the federal agency does a summary or an inventory? Yes, absolutely. A museum or federal agency only knows what it knows. And part of the process under NAGPRA is to share the information that you do have, but then to consult on that information. So consultation is key and is obviously critical to any part of a repatriation process and understanding what your objects actually are. In consultation, tribes may have criteria that they can share with you, but there may be really a need for more item by item review of something before a tribe can identify it or provide the information necessary to identify an object. So there may be general criteria, but there may not be for identifying objects. Okay. If human remains and associated funerary objects have come to light in a collection move, are they added to an existing inventory as updates or submitted as a new inventory? It's a good question. We would consider an inventory to be a singular document for a museum or federal agency. So certainly if you have additional items, you're going to want to submit a new addition to your inventory. It is both an update and a new inventory. I don't think we really have a distinction between the two. It's a new inventory in that these are new human remains that were not previously reported. But the obligation is to ensure that your inventory reflects all of the human remains and associated funerary objects in your holding or collection. So there is an obligation there to ensure you're being thorough in identifying all human remains and associated funerary objects in that inventory. So the language about whether it's an update or a new is not as necessary. You will need to be sure that you've consulted on those human remains and associated funerary objects before completing that inventory. Okay. If two institutions have a shared or split collection, who submits the NIC or the NIR? Do both institutions submit documentation for the collections? That's a good question. There are many ways that you can handle this. And again, we would encourage you to think about what is the most expeditious way of handling this. So certainly a joint notice that identifies both institutions is an option. And can be the most expeditious path. A joint notice does require that both institutions agree on the decisions that are being made in the notice. But provided both institutions agree on cultural affiliation, then a joint notice is possible. We've seen joint notices that are quite large, that involve many institutions. But again, it's incumbent upon all the institutions agreeing to that joint notice. Another option is for each institution to do a notice for its part of a collection, or alternately, again, depending on what tribal input says, what consultation says about this, it is possible that museums might transfer to one institution so that one institution can manage the repatriation process more effectively and efficiently. That is also an option. Again, we've seen a lot of variation in the resolution for split collection issues. Okay, in preparing summaries, is it better to provide one summary that includes all sub-collections or separate summaries for each consulting partner? And that's a good question. So again, summaries are for those other cultural items, not human remains or associated funerary objects. So the level of detail is up to the museum or federal agency to determine. How you organize that summary is up to the museum or federal agency to determine. There clearly could be some benefits to separating out summaries based on geographic location and potential consulting parties. So it again is up to you in terms of what information you have about your collection, what makes sense, what's logical. And then of course, again, the answer to any question under NAGPRA is what is going to facilitate repatriation. So there are a variety of answers to that question. Oh, well, I think I might actually make it through the questions this time, which is good. We haven't successfully done that yet. So that's not an invitation to add a bunch more questions, although I'm happy to continue to answer questions. Could I describe the difference between human remains and associated funerary objects on an itemized list versus an inventory? Yeah, the difference between an itemized list and an inventory is consultation. The difference between an itemized list and an inventory is consultation. And also a decision, right? So your itemized list is what you have in your collection related to human remains and associated funerary objects. You take that itemized list and conduct consultation. Perhaps additional funerary objects will be identified through consultation. Certainly, additional information will be shared during consultation about cultural affiliation. And that's the information that goes into a final inventory, a completed inventory. So again, the difference between an itemized list and an inventory is consultation and the information you gain from consultation. Nothing like a challenging question to answer, but here's one. How do we write a notice of inventory completion for an unrecognized tribe in California for the Federal Register? There's not an easy answer to this, except you don't, is the first answer. A lot of it's going to depend on the circumstances of the case and the collection. What our advice is about that notice of inventory completion. The first issue that you need to address and be sure that you have adequately addressed is if any federally recognized tribes are culturally affiliated. If a federally recognized tribe is culturally affiliated, then you would proceed with a culturally affiliated notice of inventory completion for the federally recognized tribes. If there is no cultural affiliation to a federally recognized tribe, and cultural affiliation, again, remember, means a connection to a federally recognized tribe, then the options would be to publish a notice where the determination is that there is no lineal descendant and no culturally affiliated federally recognized tribe. We are still working on the template for that, but we will hope to have that available soon. In the meantime, I would say that your obligation is to ensure you have done adequate consultation with the federally recognized tribes to ensure that there is no cultural affiliation with a federally recognized tribe. And again, remembering the revised regulations have tried to clarify what cultural affiliation to a federally recognized tribe means and to simplify that process either through identifying cultural affiliation that is clearly identifiable or reasonably identifiable. Just gonna pause for just a minute here and resort. Okay, thank you again for your patience. Okay, a question here about the difference between collections from federal lands that are in a museum facility, and whether I can clarify or explain the difference. The answer to this question is that somebody has to resolve a question of who has possession or control, who is responsible for those collections. Generally, if a collection is made from federal land, even under a permit and perhaps under a curation agreement, it is still the responsibility of the federal agency to repatriate that collection. This is a major issue under NAGPRA and one that is outstanding in many cases. And that is why the revised regulations have required museums to notify federal agencies of collections that are under the possession or control of the federal agency and not the museum that is holding or curating those. This is an important piece of the revised regulations that's hopefully going to help resolve these outstanding issues. So I can't clarify a standard, although I can tell you generally, right, that something that was removed from federal land is most likely still the federal agency's responsibility. And if you are a museum that holds those collections, you need to be sure that you are contacting the appropriate federal agency and complying with the new requirements in the regulations to send the federal agencies a statement by January of next year. For previously culturally unaffiliated or unidentified remains from a particular state that doesn't have any federally recognized tribe, what tribe should be consulted? Or should they be listed in the Federal Register as such? So for human remains that were previously listed as culturally unidentifiable, a museum or federal agency needs to reevaluate that decision on cultural affiliation. That is a part of the requirements. Again, provided those human remains have not been listed in a notice, that is a requirement to update an inventory for those human remains not listed in a notice of inventory completion and to reassess cultural affiliation. So there is information in this example of where the human remains were removed from. And that information is sufficient to identify which federal tribes, federally recognized tribes should be consulted. There does not need to be a federally recognized tribe that currently lives in the state that the remains were removed from to still identify consulting parties. There are very likely potentially culturally affiliated tribes that might live in another state today because of the legacy of removal in this country. So I would be hard pressed to describe a state where there is no consulting party, no federally recognized consulting party that can be identified. If you have questions about that, you can look at other notices that have been published in the Federal Register for remains from that state and likely be able to identify consulting parties that other museums have consulted with. If after consultation you are still unable to identify cultural affiliation, then yes, you will need to publish a notice in the Federal Register that explains why no cultural affiliation could be determined. That is the third template that we are still working on developing, but again, we hope to have available next week. And it would first require, again, consultation with tribes and an updated inventory before you proceed to publish that notice. Thank you, Mariah. Do you have any resources for organizing consultation that you can share? Mariah helpfully shared a link to our consultation record template, which again is pretty basic in terms of what information you capture related to consultation. In terms of resources for organizing consultation, perhaps how you organize an agenda for consultation, how you organize materials to be shared during consultation. That is wonderful information that you can find from other practitioners. So the regulations don't prescribe how consultation is conducted. And so we would encourage you to look to other practitioners and how they have made that, how they have organized consultation. The NAGPRA community of practice has a lot of resources like that have been shared amongst the community. including, I think, an example from the Alabama Department of Archives and History on what a consultation binder looks like. So I would encourage you to look to the NAGPRA Community of Practice for guidance that goes beyond the basics that our template provides. Thank you, Mariah, for your assistance. Okay, we just have a few minutes left. Although we have funerary objects from a site, we have already repatriated through a notice of inventory completion and have affiliated to a tribe through previous consultation. Can we go straight to submitting an NIR, or do we need to reopen consultation for the extra funerary belongings? This is a good question, and the first question to ask is whether these funerary objects are associated funerary objects or unassociated funerary objects. And that would be the first decision point, and that will tell you whether you need to, which notice needs to be published. But you do need to be sure that you're considering the definitions for associated funerary object and unassociated funerary object. And whether or not these objects meet the definition of associated funerary object that would then be published in a notice. In either case, that question itself about association or unassociation should be a topic of consultation. So there should be some consultation on these additional funerary objects that you've identified. If you do determine that these are unassociated funerary objects, then you need to first get a request from the tribe for repatriation before you can publish that NIR. Remember, a notice of intended repatriation requires a request first. So where these are unassociated funerary objects, you will need to consult or at least get a request from the tribe involved. If these are associated funerary objects, you would want to be sure you've consulted on that question, but then you could proceed with a notice for those associated funerary objects. This is a little off topic, but if we know we have inventory that is claimed and intended for repatriation and they intend to bury on federal land, is there a template or formal write-up record to follow? Are we responsible for the write-up? This is a good question, and it is off topic in large part because NAGPRA doesn't prescribe any action after repatriation occurs. Remember, repatriation under NAGPRA means the transfer of possession or control, or the relinquishment. I'm sorry, the definition now is a museum or federal agency relinquishes possession or control of those items. It's a transfer of the rights of any right, any partial interest that a museum had in the object to the tribe. That is what repatriation is. The physical process of reburial, what happens after tribes have full rights to those items, that is outside of NAGPRA and outside of the process. So, it's a little unclear from your question, but I would say that the first point is to be sure that you followed the NAGPRA steps, that there was an inventory, there was a notice, and that there was some form of a transfer under the old regulations, a transfer of control of some kind, or under the current regulations, a repatriation statement. Once that is done, then the steps that come after that in terms of reburial would be up to the tribes to determine what is necessary, what's required, and who's responsible for that. Can associated funerary objects be included in an inventory? Yes, in fact, they must be included in inventory. So if you have associated funerary objects, they must be included in your inventory. And thank you, Stephen, for adding an answer. Okay, following up on the question about responsibility of federal agencies and museum collections. What if the federal agency responsible for managing the land today is not the same federal agency that was responsible for managing the land when the collection was made? This is a good question, and it comes up a lot. Certainly, there are many lands that were managed by the General Land Office, for example, which was the predecessor to, in some cases, the Bureau of Land Management. Your goal is to try to identify the successor of that federal agency. If you're struggling to do so, reaching out to a federal agency and getting some assistance might be a good place to start. Certainly, we can assist in just general knowledge of federal agencies and who to contact and start the conversation. But in theory, even if the federal land manager no longer exists, you could reach out to the current land manager, and they can assist you maybe in identifying that other party. I do know, for example, lands in Alaska, for example, were previously under the control of the Department of Defense, later transferred to the Bureau of Land Management. Certainly the Bureau of Land Management that manages the land today can assist you with their responsibilities and what the limits of those are and who to contact. This next comment goes, I think, back to the question about states where there are no federally recognized tribes, and New Hampshire is an example. That is correct, that there are no federally recognized tribes that currently reside in New Hampshire, but there are certainly federally recognized tribes that have successfully repatriated remains from New Hampshire and who claim a cultural affiliation. Certainly the state that I live in, Maryland, does not have any federally recognized tribes, but depending on where in the state you're talking about, there are federally recognized tribes that claim affiliation and repatriate collections. So the answer is there's someone to consult with. And if, again, you can look to other notices that were published for states like New Hampshire to see which federally recognized tribes were consulted. I apologize, but I think I'm losing my voice a little bit. It looks like we have just a couple more questions. I'll see if I can answer them all. I'll try to get through the last few that we have. There's a question about non-federal agency holding cultural items that Stephen answered about trying to identify who is the responsible party. If this question is about Kumeyaay villages across the border that are affiliated with the Kumeyaay bands, can consultation go through the bands on the California side? Again, a lot of that will have to do with where the objects were removed and who has possession or control of the objects. When it comes to cross-border issues, the particulars are very important there. If the collections were made from the United States, then certainly working with the United States. If the collections were made outside of the United States, across the border, but are under the possession or control of a U.S. institution, then yes, consulting with the tribes in the United States on the California side would be appropriate. And then decisions about whether or not they get repatriated under NAGPRA is again a question, but likely very possible, even if they were removed from across the border, because they are very likely to be culturally affiliated with the tribes in the United States. Are only federally recognized tribes able to make a request for repatriation? And if so, can museums and federal agencies make a policy that allows for repatriation to non-federally recognized tribes? It seems unfair that they have no recourse to receive their ancestors' remains. NAGPRA is a federal law, and NAGPRA prioritizes, as Congress told you to prioritize the rights of federally recognized tribes. I appreciate and understand that this may seem unfair, but there is a federal relationship that is upheld by the law and reflected in the regulations to federally recognized tribes. It doesn't mean that museums can't consult with non-federally recognized tribes. Museums can consult with whomever they wish to. But repatriation under NAGPRA and under the revised regulations is limited to federally recognized tribes. There are still paths for non-federally recognized groups to engage in the process. The best way for that engagement is by working with a federally recognized tribe. We've seen that to be very successful in all parts of the country, where a federally recognized tribe works with the non-federally recognized group to achieve repatriation. That is entirely possible. There are other options, there are other creative solutions, but repatriation in terms of the process for NAGPRA is limited to federally recognized tribes. The last question, if you submit a notice to the federal agency about objects in your collection, but you don't get a response. I think this relates to the new requirements to send statements to federal agencies about federal collections. And there is a requirement in the new regulations for a museum to send the statement, as I said, within 1 year, by January of 25. After the statement is sent, federal agencies have 180 days, which is about 6 months, to respond to that statement. There is a provision in the regulations that if they don't respond, then they are accepting possession or control. So there is a built-in answer if you don't get a response, and that is that the federal agency agrees that the objects are under their possession or control. There's a follow-up question about the non-federally recognized groups and working with federally recognized tribes. Do they have to prove that they are culturally affiliated? Not necessarily. There's a secondary process under NAGPRA where a federally recognized tribe could accept transfer of human remains that it does not have a cultural affiliation to. That is the fourth notice type that I mentioned earlier, a notice of transfer or reinterment. Those provisions are under the new regulations in 10.10K. And we hope to be able to provide additional guidance on that, but for now, I would encourage you to look at 10.10K of the regulations for that option and the process there. And with that, I'm going to save what little of my voice I have left and close our session for today. I appreciate all of you attending. I hope that you found this to be a helpful session. We have another webinar scheduled for next month on May 17th, I think is the third Friday of that month. And we look forward to seeing you all again then. Thank you. Goodbye.